Welcome, I'm Lisa Del Zampo. You might have seen me playing Shelby's mom in the background of a TikTok recently. Anyone? No? Okay. I'm also a mock trial coach, and today we're here to talk to you about how can you feel strong and comfortable when you're speaking in public. We're going to point you to some videos on YouTube, and the links will be down below. One is a TED Talk by Amy Cuddy regarding presence, and the other two are about memorization, how to triple your memory, and how to memorize anything. We're going to use those principles in today's videos. Dr. Cuddy's talk on presence boils down to faking it until you actually feel comfortable and confident. And when she says faking it, she means putting your body into confident poses until you truly feel confident. For example, when people run races and win, they frequently throw their hands up in a V for victory. Or there's the Superwoman pose, hands on hips. Those two poses, besides being entered into when people are confident, those two poses translate into our brains to make us feel confident, her studies show. So get yourself into a V for victory, and actually while you're at it, screw your face up a little bit so you're smiling, which also makes you feel happy. So we want to be confident and happy. Dr. Cuddy's research shows that you must hold this pose for 2 full minutes for it to translate and connect into your brain to tell yourself that you indeed do feel strong, confident, and happy. So pause the video and let's hold this pose for 2 minutes. Let's go on to memorization tools. With these tools you can memorize anything, but for our purposes it's 2 things to learn. 1, what the rules are in mock trial, and 2, the actual factual materials that you need to know for this year's case packet. We're just going to focus on the rules for now. So for public speaking, you need to know first the rules of the venue where you're speaking. We're going to be at mock trial. You're going to be in a courthouse performing in front of real attorneys and judges. Now those videos about memorizing anything use a space memorization technique that we're going to go through on these videos for each of our mock trial rules from the case packet. The memorization technique boils down to 3 rules. 1, pick a series of symbols that have enough spaces to fit the materials you have. 2, assign 1 piece of information to each place in the series of symbols. And 3, practice imagining that place or series of symbols populated with the information you need to know. And this mock trial world is going to be assigned the different rules in the different spaces around the world. First around the world for the general rules, and then on the continents for each of the evidentiary objections rules. So let's get started on that. Here's our world that we've designed, and it's going to start with, up on top, the first thing above all else is what crime is charged. The casebook is written to have the fact situation start out everything, and you learn about what happened that day. But really, when you're talking about a criminal trial, the question is, can the prosecution prove the crime charged against the defendant? So that's why I wanted to start with the primary rule about what is a crime, the C up there on top of the world. And the crime has 2 parts typically in the criminal or penal code. That's the statute or law that we have against doing certain activities that the society has judged are criminal and will be punished. The 2 parts of a crime are a physical aspect, an action, and the second part is the mental aspect of the crime. Did the person have the culpable or blamable mental state being addressed in the casebook that year? You have to read carefully. What is the act and what is the exact mental state that needs to be proven to show that the defendant committed the crime charged? Now the next 2 things to memorize, PI and RD. The presumption of innocence, PI on the diagram. Underpinning our justice system is the idea that it's better to let a guilty person go free than to charge and convict someone who's not guilty and send them to prison. Our system presumes a person innocent until they're proven guilty by the prosecution or the state beyond a reasonable doubt. That next label that we're looking at is RD, reasonable doubt. Beyond a reasonable doubt is the test. Has the prosecution proven that the defendant committed the crime beyond a reasonable doubt? You'll see in our diagram that the C, PI, and RD are all in red. It's easier to memorize 3 things at a time, so we've grouped the first 3 things as red. You'll see how that helps you to memorize it as we go. The concept of reasonable doubt lies somewhere between probability of guilt and a lingering possible doubt of guilt. A defendant may be found guilty beyond a reasonable doubt, even if a lingering possible doubt remains in the mind of the trier of fact. The trier of fact is someone who is determining what the facts are and whether they rise to the level of committing the crime. In California mock trial in Riverside County, we will just have a judge as a trier of fact. We do not try cases to juries. Reasonable doubt exists unless the trier of fact can say that he or she has a firm conviction of the truth of the charge. To your left, looking at the label S's, the sources for the trial. You'll see a line that goes up from there with 2 new terms for us to define: circumstantial and direct. Let's start with direct first because it's easiest. Direct evidence is evidence that someone was seeing what was happening and saw the defendant take the action. In mock trial, we don't run across that very often. We do have direct evidence of what each witness actually saw. If they saw a pizza in the room, that's direct evidence of the pizza. But if we had direct evidence of the defendant actually committing the crime, we wouldn't have much to do in our mock trial. So typically, we mostly have circumstantial evidence that the defendant could have committed the crime. Circumstantial evidence is evidence that tends to prove that something happened. For example, you're taking a hike in the snow and you come across a deer coming your way down a path, and it's chewing. And as you go where the deer has come from, you see only the deer's footprints. And then you get to a clearing where you see a rose a few feet away, and the only things around the rose are the deer footprints. And the rose itself has been chewed up, torn up. Well, that is all circumstantial evidence that the deer ate the rose. But as you came up the path and didn't see the deer eating the rose, which would have been direct evidence, what you're relying on to make the determination that the deer ate the rose is circumstantial evidence. Let's take a look now at the other sources of material for a mock trial. So we go down below the S's label, and you'll see stipulations, or STIPs as they're abbreviated. Stipulations are agreements. The real deeper meaning of stipulations is that the prosecution team and the defense team has agreed that certain facts are agreed upon and not disputed. So after the fact situation in the casebook, you'll see the stipulations, and they typically start out with a few and then revise the casebook a few times through the season, where we end up with quite a few more stipulations that are undisputed. Both teams agree, and those things are things that you really should know because they're usually helpful and important in being able to produce your case or present your case at trial. The next source that we've got up there in our world is witnesses. The witnesses each make a statement that will be in the case packet. It's about 2 or 3 pages long. And that statement says their view of the world. It's what they truly know and believe. Now let's think back to the fact situation that we said was an incontrovertible set of facts. If the witness's statement disagrees with the incontrovertible facts, the fact situation would rule as to what is the actual fact, but that witness truly still believes their version of the fact. So the witness needs to stick with their truth, which is in their witness statement. We will have 4 witnesses on our side, and the other team will have 4 witnesses on their side. We'll call those witnesses to tell their story using just the facts that are important to tend to prove that crime, that the defendant took an action with the required mental state. That's on behalf of the prosecution. For the defense will call witnesses that demonstrate that the defendant did not take the action or did not have the mental state. Note that the defense never has a burden to prove anything, and we'll talk about that more in later rules. So when one team calls a witness, the attorney calling that witness conducts what's called a direct examination. They ask questions such as, what do you do for a living? What events brought you to a place that put you in a position to see what happened on the day in question? Next, the other side's attorney will stand up and get to do a cross-examination of the witness, asking questions to try to determine that that witness was incorrect, missing something, or possibly unreliable. Then the original attorney who did the direct examination will get to stand up and ask a couple of questions to redirect the witness. That is, to explore any area where the cross-examination may have made that witness look incorrect about the facts or unreliable. After witnesses, the other type of source for the trial is physical evidence. You'll see the PE there on the diagram. Each casebook will have exhibits at the end of the witness statements. Exhibits typically show physical evidence from the case. For example, a picture of a briefcase or a picture of the layout of some place that was important. The attorneys questioning the witnesses can present those exhibits to any of the witnesses and ask questions about them. And going back to those stipulations that we talked about, there's always going to be a stipulation that the physical evidence that is provided in the exhibits is the only physical evidence that is found in the case. And there is no disputing that other evidence should have been gathered. The next thing to talk about is the weapons or tools that the attorneys have to dispute some of that evidence as unreliable or otherwise inadmissible at trial. And that's the next thing we're going to get to by looking down at the continents of this world.